Okay, thank you all so much for coming and thank you for having me today. My name is Constable Melanie McIntosh and I've been an RCMP officer since May 2009. So I'm approaching 16 years. My first posting was in Okotoks Detachment. I was there for just over 5 years before I transferred to Grand Prairie. I was in Grand Prairie for around 8 years, and then I transferred down to Cochrane Detachment in July of 2021. When I came down to Cochrane, I was assigned to the domestic violence unit, but it's not really much of a unit, it's just me. So my primary job is to review all the domestic violence files that come through Cochrane Detachment and through Mînî Thnî to make sure that they're abiding by our domestic violence policy. So I put together some information. It's not exciting, but if you have any questions, please just raise your hand. I'm happy to answer questions at any time. I want to make sure that the information I provide is useful to you, so it's not just me spouting off facts about domestic violence. I want to make sure that you're able to get something out of the presentation today. Asking questions also helps trigger my memory to make sure I haven't forgotten something, or if I have a particular example or story that I could share. Okay. Does anyone have any questions right at the beginning? No? Okay. Okay, so the definition of domestic violence that we use is the actual or threatened use of force in an intimate partner relationship that may include a single act of violence or a number of acts forming a pattern of abuse. The pattern of abuse may include physical acts of violence, sexual abuse, criminal harassment, threats to harm children or other family members or pets, property damage, exerting control over movements, communications or finances, and emotional or psychological abuse. So that's typically the definition that we use to around domestic violence. We have a lot of I don't know how to say the word. There's many victims of domestic violence who are afraid to call police because they don't want to bother us, or they don't think their problem falls under this definition, or they don't recognize it as damaging behavior. So I always like to tell people that they can call us whenever. Oh, sorry, I've jumped pages here. Whenever they need help. I'll get more into that. So domestic intimate partner violence is encompassed within family violence. So it's domestic violence is sort of everything. Intimate partner violence is the violence between people in an intimate partner relationship. So it's very specific to the people in that relationship. So from an enforcement position, so from a police position, domestic violence investigations are governed by a very strict policy or procedure, whereas other types of family violence are not. So for example, violence between siblings, violence between parents and children, those investigations look a little different than our investigations between intimate partners. Does that make sense? Does anyone have any questions about that? No? So the intimate partner violence is just has a specific policy. Calgary Police Service, I think, encompasses more of the family violence in their investigation of domestic violence, but so far the RCMP has a sort of a narrowed, the policy is just between intimate partners at this time. But that's not to mean that these violent relationships don't exist between different family members. Okay. So this window I call police for help. So whenever you need help, call police. There is no remedy, there's no formula. It's not if I have a black eye or if this happened or that happened. If you need help, call police. If you feel like you're in danger, if you feel like an argument or something is escalating and getting out of your control, call us. If you need someone who's being aggressive or abusive out of your home, maybe someone who's been intoxicated and is acting out of character, or has had too much to drink and is smashing it all up, call us. Our number one priority is to protect life, so we will prioritize. If I have 2 calls coming in at the same time and one person is getting assaulted at this house and someone else's car is getting smashed at this house, we're gonna go to the house where the person's at risk. Okay, so we'll prioritize. Don't put that pressure on yourself. If you feel like you need help, you call us and we'll get there as soon as we can. There's no such thing as having enough or something has to be bad enough to call police. Call us whenever you need help. if you take anything from this conversation in your own life or with your clients or patients or whatever, it's that. If you need us, call us. So when you call police for help, we'll ask you to identify yourself. Lots of times we get people who want to report anonymously. Anonymous reports are fine. We'll take an anonymous report. But unfortunately, if we can't substantiate what you're telling us, that investigation isn't going to go anywhere. Doesn't matter what you tell us anonymously. We need people who are willing to testify in court if necessary to what they heard or saw or what they know about in order for charges to really make it through the court system. Your knowledge of the relationship or the situation is sometimes very important, especially if you have a victim who's not cooperative. And if you've observed an assault that's happened, so you call and tell us about the assault you saw, but you don't want to get involved, we can't action that. We can talk to the people that you've reported, we can talk to the victim, we can try to engage the victim and see if the victim wants to tell her version of the story, but if she doesn't, the investigation won't go any further than that. So it's really important that if you're reporting on behalf of someone, that you're willing to take it to the next level to go to testify in court if necessary, or if you can help bolster that victim or that person to give them the courage to come forward and provide their statement. For 99% of domestic violence calls or intimate partner calls, the police will attend. The only time they might respond with a phone call or a follow-up with somebody is if there's really no violence indicated. If anyone ever comes to a situation and you're worried, whether they're real police officers, there's been concerns surrounding that sometimes. Typically, the people responding will be in full RMCP uniform, yellow stripe, identified as police. If you still have doubts or concerns, you can ask to see their badge, or you can call 911 back to clarify or confirm that they have sent an officer to your house and the officers are there. When police arrive, they will separate everybody and talk to everybody individually. So they want to hear from everybody who's present, what they saw, what they heard, and get everybody's version of events and they'll call it a statement. They may ask you to provide on audio or video, depending on the situation. And again, like I mentioned before, these statements are required to go forward with charges in court. Lots of people believe that police are all powerful and the judges believe everything we say. The truth is they believe next to nothing. We can't report on anybody's behalf. I can't give a victim's version of events to police. I can't give your version, a victim's version of events in court. I can't give your version of events in court. The only version in court I can give is my version. Or that's my evidence. So my job is to gather as much evidence, which includes the statements from everybody who witnessed it, to present it in court. So has anyone heard the term hearsay? Mm-hmm. Yeah, so if I'm talking to somebody and this person tells me the story and then I go to the judge and try to tell it, that's hearsay. They're not going to listen to it. They need to hear from the victims directly or the people that witnessed the event directly. So this comes into play sometimes when we get lots of reports of potential violent situations from neighbors. They can hear something going on. They don't know what it is. They hear a woman screaming for help. They see someone running, and they call it into police. We can use their statement as to help support our investigation, but unless those people involved, those people that are actually yelling, the people that are running, unless they give us a statement or we can gather more video evidence or something like that, it'll be difficult to get those charges to the court. I'm going really fast. Does anybody have any questions? I'm from the East Coast, so I talk a mile a minute. Go ahead.
So one of the things is, say if you are witnessing somebody that looks like they're experiencing domestic violence.
Yep.
So when you're saying that unless the victim unless the victim wants to cooperate, then they can't do any charges or anything like that. What if it gets to a serious event where you see something that's very life-threatening or something like that, where it can get to that level? Would the police be able to take it more seriously and actually make something happen if life is at risk, or if it keeps escalating in different instances.
Absolutely. I would always encourage you to report what you see or what you know, whether or not we can get it to charges, because sometimes it'll at least get us into the door to talk to those victims, maybe gain some trust, open the door to let them, have a conversation about what family violence looks like, what domestic violence is, that they may be a victim of it, what we've heard. And oftentimes we can connect them to like our victim services unit or to the Mînî Thnî Crisis Center if they're not connected already. And this can help us sort of start the ball rolling to either move into a healthier relationship, leave this relationship, or to help them cope in their current relationship, or potentially go to charges depending on the situation. Does that answer your question?
Yeah.
Go ahead.
So in this community, there are obviously is big concern that people don't want to get involved because they don't want their name out there.
Yeah.
If somebody does phone and say they feel that there is something going on, is that name held private at the time?
It would be held private at the time,
right?
Probably, but it will come out. It won't stay private.
If it becomes, say, an investigation or a huge police matter, then that name would come out.
Yeah. If it goes to charges, that name's probably going to come out, and I understand that can be a barrier to reporting. At the same time, if, like I said, it gets us in the door, it gets us to put a closer eye on that relationship and that situation, and that's important. So if you want to tell something and you really, really, really don't want to get involved, or you can't get involved, that's okay. It just means we might not go to charges, but it doesn't mean we're not going to go. It doesn't mean we're not going to talk to people. It doesn't mean we're going to ignore what you've said. It just means we might not be able to get that outcome that everybody wants, a charge, someone in jail, if that's the outcome that they want.
Great.
When does it go beyond hearsay? So I know you're dealing with domestic violence, but if I'm actually witnessing an incident and somebody's been violently attacked or hurt, when does it go beyond hearsay if the victim is not willing?
That's not hearsay. So if you see somebody physically getting hurt, and then you can give me a statement and you're willing to testify in court, I can lay charges based on your statement.
What if the victim is not willing to do?
That's okay. I don't need the victim. If you see it with your own eyes, or you see it or you've heard it and there's a camera in the area that caught it, and we can put those little pieces of evidence together, we don't need the victim's cooperation. We need the victim's cooperation in most cases when it is just the victim and the offender, and that's the only two words that we have. Other than that, pretty much 9 times out of 10, we can put a case together at least to get the charges put in front of a crown. They may go to different resolutions, which we can talk about later, but at least that should get the charges laid and conditions in place. Okay?
Question.
Go ahead. Oh, sorry.
Bombard you.
No.
This is a tricky one too, but are you aware of any of the statistics with respect to the proportion of arrests as per gender, say? So like male intimate partner violence versus female intimate partner?
I don't have a statistic for you. I will say that the majority of the cases I review, it's a female victim. There are a number of male victims. Domestic violence is very nuanced, it's very complicated. There are definitely male victims. Male victims are not inclined to report. Unfortunately, that's what it is. Whether there's a stigma, whether they think it's not that bad, we don't get a lot of reports from male clients. So the majority is female. And then we do have situations where sometimes it can get complicated because we have a male reporting that they've been a victim, but truly it's a result of years of abuse the female has endured and has finally either hit back or whatever. So there's a pattern there. So in our investigation, we will try to determine who the primary aggressor is. So sometimes when we get on scene, we have a male who called us who said they were a victim, but the female has a bloody nose and a black eye and all the furniture smashed in the house. So it seems unlikely that something definitely escalated, but the victim may be the female in this case, even though the male called, and vice versa. We have cases where the female will call, but when we get there, the male is the one who's physically injured, and we can see that. So we have to ask more questions and see what we can build for an investigation. Does that answer your question? Yeah. While the parties are separated, we'll talk to the victim or who we think is the victim. We'll talk to any witnesses that are there to try to figure out what happened. If we're in a situation where there's neighborhood cameras, we might talk to neighbors and see if we can see their doorbell footage if something happened outside. We go through, is everyone familiar with the FEVR? Have you heard of the FEVR, the Family Violence Investigation Report? No? So FEVR is a list of specific questions that we ask domestic violence victims to help get a history of their relationship and the violence in relationship. Because sometimes you'll show up and by the time police get called, that's just the tip of the iceberg. There's so much going on underneath. There's been years of various forms of emotional, verbal abuse, coercive control, you name it. So the FEVR questions help pull out some of that information so we get a better picture of the whole relationship, and it helps us determine who may be the primary aggressor. So we'll ask if there's been any history of domestic violence. Has your partner been charged with violence against you before? Does he have a criminal record? Are you afraid for your safety? If this person is arrested and released, do you think he'll obey his release conditions? So release conditions is when we can put criminal code conditions on someone who's been charged to have no contact with the victim or go to their residence. So do you think your partner would abide those sort of conditions? Is your partner addicted to alcohol or drugs? Does your partner have any mental health diagnosis or concerns? Is there suicidal ideation? Does your partner have any access to firearms? Are there firearms in the house? Does he have a PAL, an acquisition license? Has he ever threatened you with a firearm or other weapon? Has he ever threatened to hurt the children or the pets? Has there been any stalking behavior, jealous behavior? So it's a whole list of questions that we go through to get a real insight into what might be going on in the relationship that led up to the police coming during the violent incident. After we do the FEVR questions, we can help the victim with safety planning, because as we know, many victims do not want to leave their relationship. They want to stay with their partner. They love their partner. They don't want to leave for various reasons, children, financial security, the list goes on and on. So we just help with a little bit of safety planning so that if they want to stay in the relationship, they have avenues to protect themselves. Go ahead.
Are all RCMP and all detachments familiar with doing these assessments and asking these questions?
Yes.
Or is it mostly primarily someone like you who is like head of like domestic violence?
No, this is required. It's absolutely mandatory for every single domestic violence investigation for all officers. So that's primary is my job, is to review the files and make sure that all of these steps are completed before the file is concluded.
So they should be doing it?
They should be doing it, yeah. Yeah. Question? No, you're good. Oh, I lost my screen. Oh, good. Here we go. Okay, so after we talked to everyone, we talked about this a little bit already. We'll evaluate all the information and the physical evidence to determine whether a charge will be laid. So we talked about this a little bit about the victim's cooperation. If there is any evidence to support that some criminal code charge offense has been committed, if we have evidence, whether it's injuries or a third-party witness or a video, something else to substantiate the 911 call to us, we will charge the offender anyway, even if the victim doesn't cooperate. Those charges sometimes don't make it all the way through the court system, but it's really important to get that victim under some conditions and get some space from the offender in certain situations to help, I guess, essentially keep the victim safe. So if we have enough evidence, we will charge the offender with an offense. There's a bunch of different offenses that fall under domestic violence. These are the ones we see most commonly. So it would be an assault with a weapon, assault by choking, assault causing bodily harm. So these things are, we can usually see that there's some form of evidence. Bruises, bleeding, cuts, scrapes, stuff we can see with our own eyes that would help us do those charges. Uttering threats is a common one. The important thing to remember in this charge or this situation, uttering threats would be death threats. So it might be threats to kill the victim. It might be threats to kill the animals. It might be threats to kill somebody else. And it could also be threats to destroy property, like burn your house down. Those sorts of threats would fall under uttering threats. Mischief is a common one we see a lot in domestic violence. It's an easy charge to get people separated, get conditions on in a domestic violence situation. So that would be destruction of property. So punching holes in the walls, smashing furniture, those sorts of things would fall under mischief. So criminal harassment, you would probably recognize this more as stalking. So that would be following from place to place, calling all the time, tracking people. We've had a lot of instances of people putting those Apple trackers in vehicles to follow their spouse all around. What else do I have on here? Showing up uninvited to your work, home, school, that sort of thing. It's basically, he's turning up everywhere you go. This is typically, well, it can happen in current relationships, but it's usually after a breakup where we see most of this behavior. But it is wrapped into coercive control, so in controlling relationships. Harassing communications is a bit lesser than criminal harassment. It would be repeated phone calls, repeated texts, basically repeated communications, using social media to contact the person. That would fall under harassing communications. Distribute intimate images without consent. So sometimes in consensual relationships, partners will exchange intimate photos. Oftentimes what we see in domestic violence relationships is one partner threatening to expose those photos, send them to family, friends, coworkers, to embarrass the victim, or in order to get the victim to behave in a way that they want. We see that quite a bit in domestic violence investigations as well. Any questions on the offenses that we typically see? No? So coercive control, which is the psychological, emotional abuse, financial abuse, controlling behavior, and verbal abuse, is tricky because it's not currently identified as a specific offense in the criminal code. And unfortunately, this is what we see so much in the early stages of domestic violence. Sometimes it never escalates past verbal, emotional, financial, controlling behavior. Yet those things are extremely damaging to a victim. But there's no charge in the criminal code that addresses that behavior. So it's tricky for us to, I guess, help those victims because there's not a lot we can do from a police standpoint because there's no charge. Some of the elements of coercive control can come back up to the charges we do have. So like uttering threats, sometimes it's in coercive control, criminal harassment, coercive control, and harassing communications can be in coercive control sometimes. But the burden of proof, I'm getting into some legal terms, but the burden of proof is harder to meet those. And sometimes you just have a partner that's just really nasty to the other one, calling names, just being a jerk, which, like I said, is psychologically damaging to the victim, but we don't have a remedy for that in the criminal code as far as charges go. So that's the most difficult thing I think I encounter in my job. Go ahead.
So when it comes to coercive control, I know that it may not get into charges, but is there like say if you get to a house where that's happening, there's a lot of other services that you can recommend for those kind of things, right? Because if it does get to that, because it could lead to like suicidal ideation, it could lead to destructive behaviors, it can lead to a lot of damaging things for the victim. So what would what would the help be for that person? So thank you for that question.
Basically, coercive control, what we do in that situation is we have a Southern Alberta Victim Serving Society. So it's that's the new name. It used to be called Victim Services. So Victim Services can help connect that person to resources in the community to help them navigate through the coercive control. I haven't had much involvement with the Eagle's Nest shelter here in Mînî Thnî, but in Cochrane, our Big Hill Haven women's shelter, I've been involved with them a little bit, and they are my favorite resource for this situation because they're so much more than just a shelter. They offer support groups and to help people recognize the relationship and maybe help them leave the relationship. So it's not that we don't disengage when we get something like this we can't charge on. We still do the fever, we still ask all the questions, and then we'll do a referral to Victim Services. If the victim says no, they don't want Victim Services, I usually recommend that we send the referral anyway, a proactive referral, just to have that name, that contact, that person that we can help connect them to. Maybe it's, like you said, mental health, Alberta Mental Health. We don't shut the door on it just because we can't charge. So if we have enough evidence to lay the charge, that person will usually be arrested and brought to the RCMP detachment. Whenever we get called to a domestic violence call, whether there's charges or not, we will ask the parties to separate for the night. If someone's being charged, the offender will be taken away from the house, either to jail or to another location away from the victim. If it's a situation where it's just an argument, a verbal argument, we don't have grounds for charges, we'll still separate the best we can. I would say 8 times out of 10, we separate them. There's a couple times where each person will refuse to leave. We can't force someone to leave in a situation where there's no charges warranted. But most of the time, everybody's ready for a break once the police get there. So we'll bring them to a friend's house, family's house, hotel, whatever they need, just to separate them for the night at a minimum. If they're arrested, they'll be separated until their matter is dealt with in the court. So if you're arrested with under domestic violence, if you're charged with an offense, you'll be on conditions not to contact the victim or have communicate with the victim in any way, and those conditions stay in place until the Crown Prosecutor removes them. We have lots of times where clients or victims want us to get rid of they change their mind after a couple days, they want to reconcile. We cannot get rid of those conditions. I can send that information to Crown and say, our victim doesn't want to go forward with this anymore. They'd like the conditions changed or removed, and then the Crown will decide. So there's sometimes a misconception that you can recant your statement or change your mind after charges have been laid. You can change your mind, and we will talk to Crown about it, but we can't just make it go away. When the charges are laid, it has to go through the court system before that stuff will be taken care of. When the offender is released, they'll be given a court date when they have to everything gets introduced into court, and they have to go to court on that date, or else a warrant will be issued. I put in here that your partner will not stay in jail. It's very, very, very rare that we can get actual jail time on the first, even on conviction, but they'll be held in cells. If they're held for what's called a judicial release hearing, we'll bring them before a judge, and the judge will release them on what's called a release order. We do that fairly frequently if it's a severe incident. If it's less severe, then the officer who's investigating will release them on what's called an undertaking. So I have the authority, or an officer has an authority to write an undertaking. So you're releasing that person on their own recognizance on scene or somewhere else with the same conditions that the judge would give. Any questions about that?
Yeah, how enforceable is that?
Very enforceable. Yeah, so if they're criminal code conditions, or if you violate those conditions, it's a fail to comply charge, which is a criminal code charge. The conditions that are have less teeth or less weight, I guess, would be conditions on an emergency protection order or restraining order, so a civil order.
So I work in here.
Yep.
So I'm never going to witness anything, but if I convince one of my patients to press charges, what can I guarantee them for their safety?
There's no guarantees. So if the person's arrested, they'll be put on these conditions. If they violate the conditions, they'll be charged again and again and again each time they charge. So they can rack up a lot of charges. And then as far as what happens in court, we can't guarantee any specific outcome.
Yeah. And they're usually out within a day?
24 hours.
Yeah.
Yeah. Yeah. Unfortunately, sometimes if the judge grants issues or puts them on bail, like actual cash bail, they might end up in jail for a while because they can't come up with the money. But cash bail is, these days, I don't see it hardly ever. It's always no cash bail or a promise to pay.
When I mean enforceable, so it's like, no contact. How much enforcement do you have for someone just going back home? You can enforce it by pressing charges again if they go back home, but really how much do you enforce if someone's been released after 24 hours to guarantee that the offender doesn't return home?
Well, we can't guarantee that they won't return home, but returning home would be a violation of the condition because they're on condition not to have contact with the victim. So if the victim's in the home, and it depends on in most situations, they're on conditions not to return to the residence either. So if they show up, they're immediately arrestable. So I guess the only benefit to that is if they show up and someone calls 911, they're arrested immediately. There's no questions asked. There's no burden of proof. There's no nothing. He's in violation. And then at that point, he would typically, if he's violating right away, then he'd be brought forth before a judge. It would be unlikely that we do the undertaking release. We'd probably bring him right to a judge for potential release, and the judge will decide whether they're going to let him out again.
For I have like a follow-up question. So if that process is going on, and then they just keep breaking that, right? Is there a certain area where it's like, hey, you're not, like, what's the threshold to say, hey, okay, well, you keep breaking these, so we're gonna throw you in jail. We're gonna keep you in jail. Is there any time, or is it just gonna keep racking up the charges and going through the process? Say if somebody does it every day. And so is it every single day that it just keeps racking up charges until court, or is there...
It depends on the justice that's reviewing. There's... Hi! Come on in. Hopefully you get a good justice. If you have enough, then they'll give a bail, a cash bail sometimes, or Crown can sometimes revoke the previous release. And then there's some different things, but yeah, as police, our only remedy is just to keep charging until a judge is like, enough is enough. You have to stay in jail.
Yeah, okay.
And to be honest, I don't see, what I see the most of, and this is where it gets complicated, I don't know if I have it on a slide here, is the victims welcoming the offenders back into the home. So they're reconciling while these conditions are in place. And I appreciate that. I understand the cycle of violence. I know how it goes. But then we get into a really difficult situation trying to enforce those fail to comply conditions. Because when we have, the judges are not all that, it's hard. There's a lot of inconsistency when stuff goes before the courts. So when we have a victim who's welcomed the offender back into the home and we have another incident, typically we will still charge with the fail to comply, but it's hard to get that charge through the court because the guy's defense lawyer or the girl's defense lawyer maybe is going to say, well, she told me to come back home. It's important to note for yourself and your clients that when you see that situation, the onus is on the person, so on the offender, the person charged, the onus is on them not to go to that house. So they can't, by the letter of the law, they can't really say, well, she asked me to come back. Like, she didn't drag you back. She's not forcibly confining you in this house. It's up to you to stay away until your charges are done. So typically in court, they used to have a reverse onus. So when you had a fail to comply charge, you had to prove to the court why you violated that condition. But I don't see that much anymore. That was when I first started policing years ago, and I'm not seeing the reverse onus so much on these judicial interim release hearings. So that's another takeaway. If you can take away from here with your clients, if you have any, they have to abide by their conditions, or else they can be charged at any time. It just depends. Again, same with judges. It depends on the officer you get, how they perceive the situation and the level of risk. If they're going to do that fail to comply charge in that scenario, there's a little bit more discretion when you have a situation when he's moved back into the home in violation of his conditions. So it's really, I wish I had like a cut and dry answer for some of this, but a lot of it turns gray. So once an offender is placed on those conditions, there is an opportunity for that person to be escorted back to the home to pack some belongings or whatever they need from the house for the period of time that they'll be not allowed to return. And then I just noted that there's nothing you can do to drop the charges. Only the Crown Prosecutor can drop the charges. Sometimes you might hear the term, I said it earlier, recant your statement. That's a little different. I even use the words interchangeably, but technically recant means if you want to go to police and tell them that you lied. So if a victim wants to recant a statement, that means they'd have to come to me and provide another statement saying that everything they said before was not true and they lied. That is not something we see very often. Typically, it's just victims who are back into the cycle of violence and they just want everything to go away and they want to reconcile and move on and not deal with the court stuff anymore. In that case, the Crown has to get rid of the charges.
Question.
Yep.
So when you take someone back to grab their stuff until this goes before the courts, what is that time window?
It's usually when they're released from jail. So if
so their condition is not to have contact
Yep.
with the victim till the court date. what is that window?
The court date can be anything. If it's a police officer issued undertaking, the court date's usually 4 to 6 weeks. If it's a release order by the judge, it can just be a couple days. So I saw someone who was arrested on the weekend. Their release order is to appear in court on the 13th. So if someone's being brought before a justice for a release, their court date is usually the very next docket day, which would be the next Tuesday. When police do it, we have a lot of paperwork together and a lot of investigation to put together before. So we leave ourselves 6 weeks before the first appearance date if it's an officer involved undertaking. It's kind of procedural, but as far as going back to the residence for your belongings, that's usually within 24 hours. So if
But I'm just wondering what do you say to them? You're going to be not coming here for a month or a year or 2 weeks or?
we don't give them a timeline. They don't.
What is that timeline normally?
It depends. So if sometimes things are withdrawn within the first couple court of appearances. So on the first court date, things are usually not withdrawn because it's usually just the introduction of everything into the court system. The second court date, which will probably be placed 4 to 6 weeks down the line, stuff might be withdrawn by then. Crown will talk to the victim. Crown will talk to Victim Services, and they'll do some negotiations on how the matter's going to be resolved. And I'll talk about some of the possible resolutions as well. But it really can vary. If it's going to go to trial, they'll be out of the house for a year or 2. Because trial dates are set usually 6, 8, 9, 10 months down the line. It depends on what the court rooms are looking like. Go ahead.
I just have a question. Do you have a situation where it's like a family in the home, like with kids, and the partner, say like the house is under like the man's name?
Yeah.
Like he owns a house technically.
Yeah.
Or it's under his name. And he's asked not to come back. Like, does he? If she's there with the kids, that situation, then she would be expected to move out with the children, so he can have the house, or
it gets a little muddy because we have zero control over that. The only court order that I know of that can do that is actually like an emergency protection order, so that can grant someone exclusive occupancy. But if the home belongs to the male, eventually it's going to be up, or I shouldn't say the male, the offender. If the home belongs to the offender, eventually it will be on the victim to probably relocate with the children.
Like, what would the no compliance order, or like the order? It wouldn't be for the house then, it would just be for the person.
Yeah, there's no order. An emergency protection order does have a caveat for exclusive possession of a home, but I don't know if the judge would grant it if the home is only in the offender's name. That runs into family court, and I'm going to talk a little bit about the differences between family court and criminal court. I'm not exactly sure, but there is a difference. So when it comes to, and I see that a lot in Mînî Thnî, because sometimes we have partners who've been living in the home here for decades, but it actually is under their partner's name. It's unfortunate, and that's where we rely on our shelters and our resources to help get the women on their feet somewhere else. But these conditions do not take into account who is the owner on the mortgage. That being said, if the offender tries to come back to the house just because his name's on it, we're still enforcing these conditions because the conditions just don't take into account any ownership of anything.
That's my question. It's like let's say it was the very next day and they haven't had a chance to move out. They haven't had a chance to.
No, there's no offender's going to come to me and say, this is my house, I own this house, so I'm going back. No, you're going to be charged. You have to work that out through divorce court. If this is your house fully, then that has to be settled in the separation agreement or the divorce agreement. Okay. Which can get really complicated. So this is a little bit of our domestic violence policy. So we recognize that the high risk associated to intimate partner violence and the difficult dynamics involved in the investigation, because there's children and there's family and there's so many different pieces involved. So they've implemented these policies to ensure the safety of our DV victims. So when I started policing about 16 years ago, we didn't really have a good, robust policy that was implemented regularly. Lots of times we'd go to these domestic violence and it would be concluded as a consensual fight, which is doesn't take into account of the power and control dynamics in a domestic violence or intimate partner relationship. So the RCMP's recognized that our CADIV domestic violence policy is we have 2 policies actually. We have a national policy that applies across Canada for all RCMP investigations. And then K-Division, which is Alberta, has even more restrictions, or I shouldn't say restrictions, more policy surrounding how domestic violence investigations are handled. So, like I mentioned before, in every case that there is sufficient evidence of a criminal offense, so if there's injuries, if the assault was witnessed by a third party, or if the offender is already bound by a criminal or civil condition that they are violating, charges will be laid. My role, I've said, is I review all the domestic violence investigations to make sure that all the policy has been adhered to the best level possible. Okay, so everything we talked about as far as domestic violence investigations are pretty similar to all investigations, even that don't involve. So, stolen vehicles or break-and enters, assaults between people at a bar. The investigations are all pretty much the same. The difference with domestic violence is the policy. So, if you're in a fight with somebody at a bar and the police show up and you have a black eye, but you just don't want to press charges, you're not going to see this guy again, you're over it. It was just a drunken fight and everybody wants to move on. We'll respect those wishes. But when we show up to a domestic violence situation and you have a black eye and you just want to move on, we're not going to accept that. We're going to lay the charge. Okay, any questions about that? That being said, as we talked about, when it comes to court, the judges might say, no, there's not enough grounds and the charge will get withdrawn or whatever, but that still gives us some time because we have laid the conditions and it gets some separation in the relationship, a chance for each person to get some space and figure out how they want to proceed. So the other investigations rely heavily on victim support and cooperation. So if my car is stolen out of the parking lot and I don't want to provide a statement, there's no evidence to put forward to a court that my car was stolen. If I just want to ignore it, then they can't lay a charge because I'm not supporting it. So there's a lot of, almost all of our investigations really rely on victim support and cooperation. Okay, any questions before we get to the next part? How am I doing on time? Oh gosh, 6 minutes. Do you guys normally go overtime or not? I should have went to this one first because it's a lot. So domestic violence and child custody issues are so closely knitted together, and it can get very complicated when you're trying to navigate custody exchange, sharing custody of kids when the parents have no contact. So divorce custody proceedings are done in family court. The police, we have nothing to do with any of that. We can't influence it. We have no part in it. It's completely separate, and the two systems don't always work together well because you'll have the family court say that the offender can have contact with the children, but the partner who has custody of the kids is not supposed to have contact. So usually they ask for a third party involvement, so it might be another family member, but then sometimes the family member is biased towards one party or the other. It just gets so messy. So what we recommend mostly is if you're in family court, if you're getting a parenting order or a custody order, is to make it police enforceable. If it is not police enforceable, we cannot intervene. The only time the police will intervene in a custody dispute is if there is a risk to the children. So if there's no safety risk, if the children are fine with either parent, we're not going to take from one parent and give to the other parent, even if the order says so, unless the order has a police enforceable clause. Because we don't have any authority. Everything police does is based on the authority, and the majority of authority comes from the criminal code. When you're looking at a civil order granted by the family courts, we need authority written into the order in order for us to act, because we can't just act on our own whim or our own wishes or what we think is right. We have to act on the authorities that are granted to us as police officers. Like I said, the criminal code gives us lots of authority, but the family orders don't give us authority unless the judges specifically outline it in the document. Any questions about that?
Yes. So if the mother has the children, but the father comes along and takes their children, unless there's a police order, forcibly order, the police won't go take the children from the dad and return it back to the mom.
No. Not unless the dad is a risk to the safety of the children. So if he's threatened the kids, or there's a safety concern or another criminal code we're investigating, we can't do that. So in some cases in domestic violence, the children might be named. Like if he's been abusive towards the children and there's a charge of an assault or sexual assault or something against the child, then the child will be named in the criminal code conditions, but the children won't be named in the criminal code conditions. If there was no offense against the child, it'll only be the victims named. Emergency protection orders are one way that the custodial parent can get an emergency protection order will include the children. So if you're fleeing a domestic violence situation or you're in a domestic violence situation and you apply for an EPO, you can ask the judge to include the children and tell him why you want the children included, and he'll probably grant that in an emergency protection order. But in criminal code, we can only put charges that are directly related to the offense. So if he's hit the children, then and if he's charged with assault against the children, then he'll be on conditions not to have contact with the children. But if the assault is only on the other parent or somebody else, the children won't be included.
So then how do you get this police enforced order? Who asks for it?
You have to ask for it yourself in family court when you're getting your parenting order.
So the victim?
Yeah.
Okay.
Yeah. So when the victim's trying to get a parenting order, an emergency parenting order in family court for custody, they need to ask for police enforceable, but they don't do it very often. The family courts are very much support both parents having access to the children, so it's not necessarily easy to get a police enforceable parenting order, but that clause is really, really, really important in order for us to be able to enforce the parenting order. So we can't make one parent or another return the children to the other parent unless there's a concern for safety. We can't make one partner or another hand over any property. So like we're saying about the house, if there's a fight over the family car and it's in his name or her name and somebody wants it, we do not get involved in that. We can't make those decisions. With the one-time exception to allow that person to come in and take personal belongings. So pack a suitcase with clothes. You're not taking the TV and the Nintendo when you walk out the door. You can take your clothes and whatever you need for your separation. Everything else needs to be dealt with through family court or your separation agreement if you're going to separate. And we can't make one partner or another pay money to the other partner. EPOs are granted by the family court, so they're similar to a restraining order, but they apply to intimate partner relationships, and they're granted on an emergency basis. In my experience, if there is grounds for someone to get an emergency protection order, there's also grounds for criminal code charges. So my preference is always to go the criminal route if the grounds exist. So rather than just the emergency protection, because the civil order is not as strong as the criminal code investigation. But it can be, sometimes the victims don't want any police involvement. So if you have clients who don't want any involvement with police, they don't want to report, they don't want any statements, they don't want any charges, they don't want to even hear the word police, emergency protection order is the way to go, because then they can apply on their own and get an emergency protection order. We'll serve it. The police have to serve an emergency protection order to the offender. But we don't necessarily have to go with charges in that case. Typically, if I haven't worked in the streets in a long time, but if I was asked to serve an emergency protection order, I would also be doing the fever questions and everything with the victim. I wouldn't ignore that because I realize that there's a whole lot more at play. But unfortunately, some of the officers, they just serve the order and move on with their day, and they don't look a little deeper into it. The EPO may be better for the coercive control. So if you have someone in a controlling relationship, they may have some luck where I can't lay charges. They may have some luck with an EPO because the definition of family violence in the PAVFA Act that specifies the EPO is more robust or like more inclusive of verbal abuse and just family violence than the criminal code definition of some of that stuff. Oh, I think I went backwards. Okay, you can request copies of your police investigations. So if you have clients who want to know the details of the investigations that they've been involved in, they can do it through ATIP. And there's a link here. I'll get this so that these slides are sent out to you if you want them. But I am going to tell you for free that it comes back pretty much black because they vet all the information that is not applicable to the person who's applying. And I haven't seen one myself, but from what I'm hearing, it basically comes back all vetted. So there's not a ton of information to be gained by requesting these orders. Any questions about that? No? Okay. Any questions at all? What am I doing? Oh, 102. That's not bad.
So if it is say for example, if there is an inclination of intimate partner abuse in that, is there other organizations, like you were talking about the special victims unit? Will they go and follow up with the people? Will they go and talk to the victims or the perpetrators or anybody like that? Because it seems like I completely understand where it comes to, is it going to be charged or is there no charges, or we can enforce it because that's the job of the RCMP. But when there's a lot more of a psychological aspect of abuse, emotional, mental, all of that kind of stuff involved, will there be another unit or something else that could be dispatched to that situation?
So Calgary Police has a better system than we do as far as the direct involvement with stuff that's not like with a team to help with that sort of thing. We rely on our victim services. So what happens when victim services, they will call the victim and follow up and say, what can we help you with? And if charges are laid, victim services are really excellent because they'll help the victim through the entire court process. They'll call Crown, they'll liaise between the Crown and victim, they'll get ready for trial, court prep. All of that is really good for the court stuff. They will talk to the victim and suggest certain agencies. In most cases, it's a shelter, so it might be Eagle's Nest or Big Hill. And then they'll refer to the shelter to help them. The shelters are, in my experience, the best because they'll help you get an EPO. If you want to get an EPO, they can help you through the process. And the crisis center here as well. I think they'll help you get an EPO. They'll help you through some of the family court stuff. So victim services will connect our victims with these agencies that can help them do more, like help them get the parenting orders and help to do the stuff that doesn't fall under our CMP control, I guess. Does that help?
Yes.
A little bit? Yeah.
Is there other places you can, like I know crisis support, for example, but if there is a situation where police are not wanted or not welcomed, right? Is there other organizations that can be called to be dispatched to certain areas or to assist in those kind of things? Because sometimes police are some people just don't want police around, but they do need assistance.
Yeah, and so there's no like first response other than police. So even if we go on that first response, then we'll connect to the people they want to talk to. Do you know what I mean? So like it's not safe to send like a civilian team or whatever into any domestic violence situation. They're the most high risk, most violent, most volatile situation possible. So really police are the only option for responding to dispatching to someone's home and trying to deal with it. But if they don't want to deal with police and they just refuse and everything goes bad on scene, we can still make that connection to victim services and help them get a more civilian scenario.
Okay.
Does that make sense? And then, of course, like I said, the shelters are excellent resources, the crisis center, to give them information that they need if they don't want to come to police. They have a situation they need to talk about. Those centers maintain privacy. They don't have, they won't necessarily report unless it's an extreme risk of safety to police. So that's kind of a safe space where they can discuss their situation. In Big Hill and Cochrane will do a safety assessment with them, a risk assessment, and go through pages and pages of stuff to help them figure out their situation. Any more questions? Okay, so before I let you go, I just had two more things that one thing I forgot to put in and one thing I learned after I did the presentation. I wrote it up a couple weeks ago. We all know that there's a risk between animal abuse and violence. It's sort of like I guess just a common knowledge, I suppose, that if someone's abusing animals, there's a good chance they're going to abuse humans. The link between animal abuse and domestic violence is actually very, very, very high. They're starting to do more statistics, more research about the link between the two. And if you're seeing clients and you're seeing animal abuse, that's a huge red flag for domestic abuse as well, against the children and the spouse. So in a place where we have abuse against animals, the RCMP does have animal cruelty charges that we can investigate or pursue. So if you suspect animal cruelty, it's not a bad idea to report. If you've had information about animals being abused as well as people, it might not hurt to report the animal abuse as well, because sometimes that's leading to domestic abuse as well. The other thing is Clare's Law. Has anyone heard of Clare's Law? Yeah?
Yep.
So Clare's Law is, the Alberta government has introduced Clare's Law, and it's a law that allows victims of domestic violence to send in a request to get a history of an offender's, basically get their domestic violence history. So they can go to the Alberta government website under Clare's Law and make an application. What happens is the application, they pull all the information from all the databases about the person. All that information is sent to our threat assessors, the ITRAC, the Integrated Threat Assessment for the province. They will do like a risk assessment threat summary about that person's domestic violence history. And then if it's in the Cochrane area, it gets sent back to me, and I will meet with the victim and tell the person the history of their partner. Does anyone have any questions about that?
So with that, anybody that's with a partner can request that information.
Yeah, so the only caveat is that you have to have concerns. So if you're with a partner and you have concerns that your partner is going to escalate to abuse against you, whether it's like yelling behavior, mental illness, whatever, you can make a request to Clare's Law to get a copy, or not a copy, it's a summary, basically a little threat assessment on their history of domestic violence. So typically what I see when I get back is like a paragraph, 2-3 paragraphs that summarize that offender's domestic violence history with other partners. From a police standpoint, it's interesting to see how the victims, how they change when you read it to them, when you say, yes, what happened to you is domestic violence, and it's happened to your spouse's, all these other people he's been with. It doesn't give specifics. It doesn't give the name of previous partners. It doesn't give any dates or specific details. It's just a very general summary of that person's police or criminal history. But I've seen how valuable it is to victims to read that and hear that, and it's just sort of like they just feel vindicated and that they're not the only ones. So it's used to help them make decisions about their safety, so whether or not they want to stay in that relationship or not, and we connect with safety planning and resources at that meeting as well. So that's kind of another good way to get introduced to police without having to tell me all the domestic violence, because I will just read Clare's Law and I can't act on it. So as a police officer, if you call me to a domestic violence, I'm bound by policy. I have to do this policy, I have to charge. But Clare's Law is a little window where I can give you this information dangerous that you can use for your own benefit without really prying into your relationship and determining if I should be doing a criminal code investigation. Does that make sense?
When we see or think domestic violence, right away we think spousal. It's about relationships between two partners.
Mm-hmm.
But domestic violence can mean other areas as well, where they're usually kept, let's say, in the gray, I'd say they're gray areas, right?
Yeah.
Where we emphasize mostly on partner relationships. When we say domestic violence, right away, the first thing that comes to mind is the relationship.
Mm-hmm.
Okay? But as we still don't understand that it can include other areas of violence as well.
Yeah, from other family members and other, even close friends and associates. Yeah. Any more questions? Yeah.
I'm sorry. One more. So I know this is definitely for intimate partners, but say even if it's in a household and there's certain types of abuse that's happening within the household, like say financial control or threats or anything like that. Mm-hmm. So I know that you were talking about how it's done in a different way. Mm-hmm. So it's not as, I'm not saying it's as like urgent, or not, because I know that there's a different way about that, but is there like when it comes to domestic violence, could it be just people living in the same household? Could it be like siblings? Could it be like all of those things in the same? Yeah,
absolutely. Those offenses that are happening between people that are not not intimate partners, it should still be reported, because it is still serious and it is still violence, especially the uttering threats, abusive behavior. All of those things still apply to everybody in the family. It's just the policy looks a little different from a policing standpoint. So I don't want to negate any of those sort of family offenses, because I know there's plenty of violence, abuse, financial abuse between elders and children, or children and elders, siblings, aunts, uncles. Like, it exists within all the family relationships, and they're all equally important, and they're equally as risky as domestic violence. It's just we don't have a specific policy to deal with a sister and brother fighting versus the spouse fighting. Do you know what I mean? So there's still criminal code investigations. They're still serious. They're still important to investigate, and police will attend, and that they should be called for all of that stuff, or reports of that stuff. It just looks a little different from the charging perspective, and whether or not there's sufficient evidence to bring it to court. So it's all the same. It's just a slight difference in that we recognize that the high risk associated with intimate partner violence has resulted in these basically charging without the victim support in a lot of cases. Okay.
Great. Thank you very much.
You're welcome.
Thank you, Melanie.